Welcome to our second day of joint judiciary. We call the roll, please.
Mr. Chairman, this is for joint judiciary for May 13th. Senator Craigo.
Here.
Senator Crum. I don't see him online. Senator Hicks. Senator Kolb.
Present.
Representative Brady. Here. Representative Bratton.
Here.
Representative Chestick.
Here.
Representative Filer.
Here.
Representative Kelly.
Here.
Representative Lean.
Here.
Representative Singh.
Here.
Representative Webb.
Here.
Co-Chairman Olson. Here. Chairman Washut.
Here.
You have a quorum, Mr. Chairman.
Thank you. So just a reminder on our decorum. Got a lot of familiar faces, experienced hands being at these meetings. We just treat each other with respect, and we get along just fine in here. If you have any questions about our rules of decorum, there's copies at the door with the agenda and meeting materials that you can review. Also today, when we're taking public comment, we're going to reserve the right to try to keep that comment specific to the topics that are before the committee. And so sometimes people come with a wide variety of interests and come to these meetings, but the public comment will be specific to the topics that we address, and each topic will take public testimony. All right. So with that, Ms. Butler. Mr. Co-Chairman, any opening comments?
No, thank you, Mr. Co-Chairman. You said it perfectly, what I was thinking about. I guess I will just say that, we have to be a little fluid. So that's my opening remark to the public, is that sometimes there might be plenty of time to devote to a topic and testify on a topic and discuss a topic. And other times we're pressed against the clock, and that's just the reality of how it works. So we just have to be flexible as we go. Thank you.
Okay. With that, we turn to our first topic of the day, the Wyoming Judicial Branch update. Ms. Butler.
Mr. Chairman, Mr. Co-Chairman, members of the committee, my name is Elisa Butler. I am the State Court Administrator for the Wyoming Judicial Branch, and I am pleased to be here with you today. For our Judicial Branch update, we're going to do something very short and sweet. We'll be talking to you quite a bit this afternoon, and so I thought I'd provide a little bit of information for the committee on where we're at overall with court automation projects. So public access and remote public access are part of what we call court automation. So there are a number of systems, enterprise technology systems that we have throughout the branch. And we've been working on those for many, many years. And so I wanted to provide you all with just a bit of history on where we're at with those projects and essentially what it takes and how long it takes to implement a new enterprise system in the judicial branch. So what you have or should have in front of you today is a timeline of the court automation projects. You'll see at the top, it says History of Court Automation in Wyoming. And so this is, again, just a timeline. We, in 2000, this legislative body enacted the Judicial Systems Automation Account and Fee. And so that is a special revenue account that goes to the judicial branch to pay for our enterprise software systems. Initially, that account and fee was enacted to get us to e-filing. That was the purpose of that fee, was to get all of the courts in Wyoming, all of the judicial branch courts, and I'm accepting municipal courts because they're not part of the judicial branch, but all of the judicial branch courts on one system to allow for the implementation of e-filing in Wyoming. So that fee was enacted for that purpose. It has been changed over the years, I will tell you that, and we'll get into a little more of that as we talk this afternoon, just in terms of the amount of money that comes out of that fee. Or that account, but that was the original purpose. And so that is really what the branch did for, the last 26 years, is we worked toward creating an e-filing system for the state of Wyoming that is uniform statewide. I will say, I don't think we're entirely unique in that regard, but we are pretty special because we are what we would call a non-unified judicial branch, meaning that In many other states with a unified judicial branch, every court sits under the authority of the Supreme Court. So the Supreme Court governs all courts in that state. Wyoming is different. And so we are a non-unified branch. The Supreme Court has authority over the circuit courts and the Chancery Court in Wyoming, but the district courts are independent. So each judge is an independent entity. And as you all know, the district court clerks are elected county officials. So we are non-unified. I don't know of another state, although there could be one, where we have a non-unified branch with a uniform case management and e-filing system. I believe that's probably unique to Wyoming, although I could be wrong. In most non-unified states, each clerk's office, district court clerk's office have their own case management system, their own e-filing system. The advantage, of course, to uniformity and having a uniform system is data. Data is huge, and we are able to capture that data much more efficiently with one unified system, uniform system. And then the other piece of that is it allows for those who use those systems, so right now primarily attorneys, to be able to e-file into one system rather than having 6 or 7 that they have to e-file into across the state. So there are some very real advantages to that kind of model where we are providing one system for all of the courts in the state. So starting with the timeline, as I said, the JSA fee and account was adopted in 2000. We began work on our first case management system for the circuit courts right around that time. And so that took us 3 years to implement. That circuit court system did not include documents. It just included data. So we would have documents filed over the counter. Those weren't scanned in at that time. What the clerks did is they just entered data about each case. And then they also tracked things like payments and funding to ensure that the money was going to the right entities. In 2006, we started on a project for the Supreme Court for a case management system and e-filing system combined. And it was the first e-filing system in Wyoming at the Supreme Court. We called that C-Track. That took us 2 years to implement from 2006 to 2008. And then on the heels of that, we started working on a district court case management system that would be used throughout the state. And so that system was very new to us in the state of Wyoming because at that time, the district courts were all on different case management systems. I shouldn't say all. I think we had, 6 or 7 case management systems that were used by the district court clerk's offices at that time. And we transitioned to using one case management system in all of the district courts from that time, 2009 to 2014. So that was the transition that took place at that time. That transition was really important to set us up for e-filing moving forward. In 2016, we actually ended up upgrading all of the trial courts on a new case management system. So that was circuit court, district court, chancery court. All of the trial courts are now on one case management system. It's the same one throughout the state. It's called Full Court Enterprise, and it's used in every judicial branch trial court in the state. And then following that, we worked toward e-filing. So we started the e-filing implementation in 2020. We are still working on that implementation. So we finished the district courts, chancery court, and now we are nearing the time when we are going to have e-filing statewide in all courts. The circuit courts will be wrapped up in early 2027. So that is, there are other, I don't want to give you the impression that we haven't had other projects because there are many, but this really is the timeline when we think about court automation, when we think about the enterprise systems and the things that we need to move forward to become essentially a technological branch that operates with technology in this day and age. So Mr. Chairman, I don't know that I have much else to provide just with regard to that kind of update. This is something we thought would be helpful for the conversation this afternoon, but I'd be happy to answer any questions about this timeline and court automation or any other questions with regard to the judicial branch that the committee may have.
Committee questions? Representative Ling.
Thank you, Mr. Chairman. Excuse me. Thank you for joining us today. My question is, do we, excuse me, Do we send this out for an RFP or is this done in-house with tech people?
Mr. Chairman, Representative Lean, these are all contracted systems. So within the judicial branch, we have 17 IT people. So 8 people who work on software applications and 9 who work on kind of the infrastructure and hardware for the branch. So quite frankly, we just don't have the staff to do any development in-house. So these are all contracted systems. We go out to RFP, we contract with vendors to obtain these systems, the code for these systems, and then in many instances, they'll help us implement.
Follow up, please.
Thank you, Mr. Chairman. My follow-up would be, what about security? We know in today's world, technology security is really important. Could you talk to us if there's some challenges or benefits or what you see happening right now with this
Ms.
system
Butler.
in the courts?
Mr. Chairman, Representative Lean, yes, very much. That's something that we definitely look for regularly in terms of vendors and how we select. All of those systems live behind a judicial branch firewall. I'm sure it's more complex than that. If somebody from my IT office was here, they would give you much more accurate terms, but they live behind our judicial branch firewall on the judicial branch network. So that is something that our branch controls and we look at regularly. So we have, annual cybersecurity audits. We have logging and tracking and constantly looking at if there are any bad actors trying to intrude within our network. And so that is very important. It is a very important piece, especially as we talk about moving to something like remote public access and ensuring that we have those cybersecurity safeguards in place.
Other questions? So Ms. Butler, I suspect that this is kind of like the highway department, right? That this is going to be ongoing, that we don't have an end date, that what's the life expectancy of these systems? How often do you anticipate having to replace or update? Is that a continuous thing or is there a life expectancy that in 6-7 years we have a massive demand for cost to upgrade?
Mr. Chairman, it's a great question. I would say a couple of years ago, what I would tell you is we would need to update to a new system about probably between 7 and 10 years is a good life expectancy. I can tell you nobody, and I'm looking at the back of the room because the district court clerks have been through all of these implementations and they are not the most fun things in the world. So we try to get the most life that we can out of all of these systems. But what we are seeing, and I'm sure you've heard this from other agencies, is we're seeing a move for most of these vendors to move to a software as a service kind of system. So our e-filing system is a software as a service system. And we're seeing a lot of these other vendors move in that direction. So essentially what happens is there isn't one system that becomes end of life at a certain time frame. It is a constantly updated system that you subscribe to, and the vendor is constantly developing that system and providing enhancements and customizations and keeping it up to date. What we've seen is that increases the cost of those systems. So like when we implemented, I would say full court, which was the first circuit court case management system, that was one piece of code that we installed on our server and it was there, right? So, we didn't really have a vendor touching that code at that time because it was installed on our server and the clerks just used it for that period of time. That is no longer the case. And so like our e-filing system is housed in the cloud with the vendor. And so they're touching that system regularly to update the code. And so that is the shift that we're seeing. What we've seen from many of these vendors is they will tell you essentially, we will support that system up through the 2025 update. And then then you have to move up. So it's 2030, you're on 2025, you're now required to move to at least 2027. And so it's a constant kind of moving target that we're going to be looking at, I think, over the next few years.
One Representative Webb.
Thank you, Mr. Chairman. Ms. Butler, can you give us your best guesstimate of when we're going to have remote access available to the public?
Ms. Butler.
Mr. Chairman, Representative Webb, I honestly, I can tell you that if we began that work soon, and then when I say soon, I would say before the end of the year, I would, my best guesstimate is it would take us 2 to 3 years to implement. And we'll get into a lot of this, I think, this afternoon, but there are many, many policy questions related to remote public access and what kind of sensitive information should be revealed to the public and what maybe shouldn't. Also, I think there are quite a few questions about what does remote public access mean to you? I mean, and so when I think of remote public access, I think of remote public access in terms of documents and the availability of documents, but I know that's not everybody's definition of remote public access. And so yeah, I would say that is probably the minimum time frame of when we could get a system up and running. And again, it would be all dependent on ensuring that we are thoughtful and conscientious about how we implement that system.
Thank you. Ms. Butler, I've been reading about these cases where lawyers file pleadings and so forth, assisted by AI, only to find out that some of their cases are manufactured, they're non-existent. Does your software on your e-filing system have any capacity for pre-screening those types of pleadings to alert the branch that some of the material was submitted to an AI source?
Mr. Chairman, our system does not. It doesn't mean that that won't be developed, and there may be, I haven't heard of any, but I don't know of any systems that are doing that today. I would venture to guess many of those vendors are looking at that right now, but our system doesn't do that today.
Mr. Co-Chairman, somehow I picture that as AI checking the brief to make sure there's no AI citations that were developed by AI.
Very well may be, yeah. They're gonna be in charge. Be nice to them. Anybody else?
Mr. Chairman.
Representative Singh and then Senator Cole.
Thank you, Mr. Chairman. And just for the public's benefit, we have automated decision-making by AI on the agenda for the blockchain committee. So it is something that we'll be talking about. And so I'm interested in hearing what is heard today.
Could AI serve in the legislature?
Not, no, I don't believe so.
Senator Cole.
Yeah, thank you, Mr. Chairman. Morning, Ms. Butler. What's your definition of remote public access? Thank you, Mr. Chairman.
Are we getting ahead of ourselves? But we can, go ahead.
Mr. Chairman, I'm happy to answer. And Senator Kolb, I think when we have been thinking about remote public access for a lot of years now. In fact, I think Senator Olson, back in the day, we had a conversation with the legislature about it when we were moving toward e-filing. And the way that I think the people in my office, we generally think about it is remote public access to documents. And so allowing, similar to what we have public access terminals in our courthouses, similar to that, only availability remotely. And so again, that's my definition, but I think everybody has a different idea of what that should look like.
Don't see any further questions. Thank you.
Thank you, Mr. Chairman.
Any other state agencies or branch personnel want to speak to the judicial branch update? Anybody? Anybody from the clerks, Nubway? Anybody on Zoom? Okay, we're gonna close public comment on Wyoming Judicial Branch update. That will take us to our 9 o'clock, so we're cooking right along. Our criminal code review, what we've all been waiting for and looking forward to. Our chance to dive into not just Title VI, but the whole of the criminal code. I think I'd like to start with the overview provided by LSO about the different gradation systems available in different states. So who's going to take that? Clarissa?
Mr. Chairman, members of the committee, Clarissa Nord with LSO. So this morning I'll summarize the fact sheet in front of you, and this is regarding other states' criminal offense classification systems. And this is included in your materials as Appendix 12-03, and it relates to the committee's approved interim topic on Title VI in the criminal code review. So just for an introduction, this fact sheet primarily focuses on felony classifications. I wanted to note that Appendix A, this is also included in your materials. This provides background information on misdemeanor sentencing trends, which were previously identified by NCSL. And so that may serve as a good resource for you all. So generally, a number of states structure their felony systems by class or degree. And these systems are typically organized from most to least serious in terms of the crimes. And they establish penalties for each classification, including terms of imprisonment and fines. And states vary quite a bit in terms of how detailed these systems are, and if they include additional aspects like post-release supervision. So for this fact sheet, we looked at Colorado, Nebraska, New Mexico, North Dakota, South Dakota, and Utah. And there's a number of tables included in the fact sheet. I won't review those for you all today, but they just provide a couple of example offenses for context, and they're certainly not exhaustive for each crime that fits within that class or degree. And then the fact sheet also notes when each state adopted its classification system. So just quickly, a couple of observations about each state. Colorado, they use a class-based system, and they have classes 1 through 6, and they also have a separate drug felony level classification. And then they designate some offenses as crimes of violence or extraordinary risk offenses, and this can increase their sentencing ranges. Nebraska, they classify felonies into classes 1 through 4. They have a number of subclasses as well, and their higher level felonies can include mandatory minimum terms or post-release supervision requirements. New Mexico and Utah, they classify felonies by degree rather than class, and their statutes set maximum prison terms and fines for each degree. And then North Dakota and South Dakota, they use class-based systems, and they have fewer distinctions within each class compared to Colorado or Nebraska. So altogether, these states differ in terms of how much detail is included in statute and how their sentencing ranges are structured. Finally, Appendix B, this is also prepared by NCSL. There are additional examples from other states for reference. And Mr. Chairman, with that, I'm happy to answer any questions.
Thank you for that great report. It's got a lot of information at different systems. Committee, any questions for Ms. Nord? As you did this research, was there a sense that any of these systems is more popular perhaps than other systems, or is they're scattered across the board?
Mr. Chairman, that's a great question. I would say each state varies quite a bit in terms of how they structure their classifications. It varies in terms of whether they use degrees or classes. Degrees are typically broader, and they leave a little bit more room, whereas classifications, those classes are a little bit more tailored and narrow.
Representative Lee.
Thank you, Mr. Chairman. On the Appendix A of the state's handout that you were just reviewing, at the top there it talks about an increased focus in recent years on changing sentencing schemes. And I was wondering if you had any examples of that.
Ms. Nord.
Mr. Chairman, I don't have any specific examples on hand today, but I'd be happy to follow up and provide that information.
Further questions? Okay. Anyone in the room wishing to discuss classification systems? Okay. Well, all right, got one. Brave soul. Good morning and welcome.
Good morning.
Make sure you have your green light on, identify yourself for the record, and then tell us what you'd like us to know about classification systems for felony crimes.
Good morning, Joint Chairman. Thank you so much for having me. My name is Clayton Malinkovich. I am the Sublette County Attorney. I am here on behalf, excuse me, of the County and Prosecuting Attorneys Association, and here with me is District Attorney Sylvia Hackle, and I'll let her introduce herself.
Good morning, Mr. Chairman, members of the committee. My name is Sylvia Hackle.
And we are here just to be available to answer any questions that you might have of the prosecutors. We have met as a group to discuss this from the perspective of where we all review this more than anything from more of a rhetorical question of what is the goal? What is the goal of this potential change? And how that could be met through this, and then more than anything, we are available and want to participate. Generally, the Prosecutors Association is opposed to these gradients, largely because it can limit the discretion of prosecutors individually in each county, but also it can create confusion and more than anything, complicate an already relatively complex system. But would stand for any questions that anybody has about the way we approach prosecution, from the prosecutorial decision to sentencing, all of those things. Or unless Ms. Hackle has anything else to add.
No, I do not. Thank you, Mr. Chairman.
Representative Shestak.
Thank you. And I didn't catch your last name.
Last name is Milinkovich.
Okay.
Common spelling.
Common spelling, yes.
Yeah. I'm curious about your reasoning or your thought process in concluding that having a classification system is more complex. It seems to me less complex if you have categories that you can say, oh, these crimes are similar and should be treated with similar penalties, rather than have it pretty much random and whatever that particular legislature thought that year, and then 10 years later somebody else says a different thing. It just seems way more complicated to have it the way we have it, and categorizing things and putting them in neater little boxes seems to be simpler to me. What is your thought process, and why you think this proposal is more complex?
Mr. Chairman and Representative Chestik, I'll give kind of an anecdotal way to look at this. One of the things that each prosecutor reviews on the daily basis, multiple a day, are criminal history reports that come through the National Criminal database of what a person's criminal background is. And I'll give you an example. For example, when you look at, and the packet alludes to some of these states that have these gradients, but Texas is one that we see quite often because we have a lot of Texans that come through Wyoming. And so we see a criminal history coming out of Texas, and we see felony grade this, felony grade this. And from that perspective, it does get confusing as, okay, what is this? What limitations do they have? How does that felony coincide with our felonies? And then that ends up being somewhat complicated from that perspective. The other, and I'm trying to reduce a variety of comments from my counterparts throughout the state into one statement. But the reality is that in a situation where we have these gradients listed out, it more than anything is an extra step in that prosecutors are seeing as not necessary. And it's hard to really have this conversation without understanding where the goal, like what the ultimate goal of a gradation process is, if that helps.
So let me chime in on that aspect, since I was the one that brought this to the committee for interim look. It seems to me, and I think the spreadsheet that LSO prepared for us suggests that we have quite an array of penalties provided for 1,000+ offenses scattered through 3 or 4 different titles of the green books. And as time goes on, we lose track. We were talking before the meeting today about folks hitching a ride on a freight train as a 10-day mandatory minimum. And when's the last time we prosecuted somebody for, riding on a freight train? So interesting like that. At the time that was passed by the legislature, it seemed to make sense. And I'm sure that body thought that that was the appropriate penalty for dealing with those types of offenses. Now we're in 2026 and we're taking that kind of look back saying, are these penalties still appropriate? And when we look at two crimes with very similar elements, for example, the one I like to use is felony eluding and aggravated assault. The elements for at least subsections of those crimes are almost identical. Yet one's a 5-year felony and the other's a 10-year felony. So those are the kinds of things I was hoping that I always think it's beneficial for us to every once in a while pause and look back and say, what does the body of work look like? Does it still make sense? Are we drifting in ways? You know, we have 3-year felonies, 5-year felonies, 7-year felonies, 14-year felonies, 15-year felonies, 20-year felonies, 25-year felonies. We're all over the place. Right? And so that's my thought, was that a gradient system should be at least evaluated. Doesn't mean we have to adopt it. And if the prosecutors are strongly opposed, maybe that guides our decision. But I thought it was at least worth the discussion, that hopefully make things a little more consistent, perhaps easier for people as we go forward, creating new felony crimes, to be able to say, is this crime closer to aggravated assault or is it closer to burglary? Should it be a class B or a class C felony, or should it be a level 1 or a level 4? Yeah, those sorts of things. So that's the thought process behind it. Hopefully to make things clearer and less complicated, as Representative Shestak suggested, rather than more problematic. So with that, any further comments from either of you?
Yes, Mr. Chairman, if I could respond, and thank you for that clarification. I think that does help us. You are very correct in the fact that we have a variety of criminal statutes spread throughout. You saw and I took the printout, because I was like, this is great. I want this on my desk. So thank you to those who prepared and painstakingly took all the effort to prepare that. That is something that I'm sure that most prosecutors around the state will utilize on the daily. Having prosecuted a person in the last 12 months for failing to provide livestock water, which is on the list, I double checked. It got caught, but there's a variety of these things in there, and you are exactly correct. And I guess from the perspective of the Prosecutors Association, with that rhetorical question of what is the goal, certainly we have seen a variety, and your thinking is correct from our perspective. We agree with you on many things, to go through and do a look back of what things are we considering a crime in the state of Wyoming, and is the penalty appropriate, makes sense. And what I'm hearing is, and I guess this is a question for you and the committee generally, is this something from the perspective of, let's say for discussion's sake, my misdemeanor that I described as a failing to provide livestock water, that's a certain grade of a misdemeanor. The misdemeanor you described of hitching a ride on a freight train, which some friends of mine in college did for fun, and I don't understand why. But if we're looking at that and we say, excuse me, in 2026, we've defined the livestock water as level 1 misdemeanor for discussion's sake. And we've said that the riding the freight train is a level 2. Are you suggesting that we have defined what those grades are in 2026, and then instead of going back through to address every single statute in 50 years, we as a state can simply say, we're just going to adjust the grades, and then the grade applies uniformly? Am I understanding that correctly?
Potentially.
Okay.
Yeah, we don't control future legislators. They'll do what they choose is duly elected.
But Mr. Chairman, I guess that could be an easy button, so to speak, on adjusting, because it sounds like the question is our current penalties appropriate for current crimes? And that could be an easy way to update it. And from that perspective, I would suggest, personally myself, I would agree with Representative Shestak that would make it simpler from the legislative fix perspective, that you could simply say, we're just moving all grade 1 misdemeanors to a certain penalty. And I guess to back up a little bit, and if you don't mind the detour back to the conversation with Representative Chestick, not necessarily is it a complication from the prosecution, what is the charging and understanding what the penalties are, but realistically from a negotiation perspective and working through and prosecuting a case. As you all are likely aware, the vast majority of criminal cases are settled through plea agreements. Oftentimes the word plea agreement is a byword that folks don't like. But the reality is nationwide, the statistics are between 98 and 99%. And that comes from a place of complication for the courts. They're here in the room. They can talk to you about their dockets and what they're available to do. And so the reality is that most of our criminal cases go through that plea agreement process. And where gradients create fixed, defined results, it limits a prosecutor's ability and to work with defense counsel. I saw the public defender's office in the room, and hopefully they can comment on this as well. But we work hand in hand with these folks week after week, day after day, to reach these kind of agreements. And that's what I mean when we're in this complication aspect. If the legislature is telling us through the legislation, through the statutes, that you have to put a person in this more narrowly defined range of sentencing, it just makes it more difficult to settle these cases and get these things taken care of from a judicial economy perspective.
Representative Chestick.
Thank you for that clarification. But the concept that I'm working with here is that when we have these classifications, there's still going to be a range minimum to maximum within each category. So you still have that range of flexibility when you work on a plea agreement. You still have a lot of flexibility, and you can, you argue for higher, they'll argue for lower. So I'm not sure how, whether the range is set by a categorization or by individual criminal statutes. Why does that matter what the source of that range is? It's still a range you can work with.
Mr. Wilson.
Thank you, Mr. Chairman and Representative Chestick. I see what you're saying. I do. And we are always going to have that range because guidance coming from our Supreme Court also is to look at the person that committed the crime, what their history is, what their characteristics are. We look at a pre-sentence investigation, all those things. And we also look at the nature of the crime itself to find a place in that range. I guess my concern, and again, this is difficult because you're hearing a lot from me individually because we have not had a solid question to then circulate amongst the group. So I hope you'll forgive me, and I hope Ms. Hackle will chime in as well, so you can get a second perspective on this. With that, if we have a variety of gradients, my concern, and I think this can be borne out in the communication amongst our association as well, is that if we, for misdemeanors, for example, the vast majority of misdemeanors are a 756-month misdemeanor. There's a few that are outside of that range up to $1,000 fine and a year in jail, and then they also get down to the up to 30 days in jail or up to 20 days in jail for some of these, and forgive my use of the word, archaic statutes, such as the destroying a legal fence statute, which was, I believe, most recently updated in, I think, the last century, not this one, but the one before, but it could have been the previous century before. And so that's why I'm using the word archaic. So yes, we have a current range right now, but if we start getting into grading misdemeanors, my concern personally, and I can kind of see this from the group, is that if we're saying we have 1 through 5 or 1 through 4, then the legislature's picking these ones, and that's where you have that limit of discretion. And that's what I mean with that, with the more difficulty with a plea our plea agreements and reaching those plea decisions.
So Mr. Malinkovich, is this your sense of of your association that folks are comfortable with what we have and see no need to change?
I think that's a very boiled down, I'm sorry, Mr. Chairman. I think that is a very boiled down way to say it. When we look back at the way that our criminal prosecution process has been set up through the state, it is set up so that each county is different. Each county has an individually elected prosecutor. So for example, Sublette County, I serve as the elected prosecutor there in that county. There is the hallmark of prosecutors acting as as in the executive branch. That discretion is crucial, that prosecutorial discretion. That's why they're elected. That's why we answer to the people. And so I would say that speaking for the group, any type of legislation that seeks to limit our ability to have that discretion, to serve in the role as the rules of professional responsibility describe as a minister of justice, we are generally opposed to.
So, Mr. Malinkovich, you're negotiating a plea with a defense counsel, and whether you charge that crime or allow the individual to plead to a class 3 as opposed to a class 2, would having these crimes in different classes limit your discretion to allow that defendant to plead to a crime in a different category? I'm trying to understand how putting crimes in A, B, C, D, or 1, 2, 3, 4 somehow limits your discretion.
Certainly, I'll try to give an anecdote. And I do know from our conversations previously that Ms. Hackle has significant experience in the federal system where this is somewhat borne out in sentencing guidelines. And I do know that she has some good input on this as well. I'll give an anecdote just for an example of what comes to the table amongst for a standard arrest. Prosecutors come to the office, we read the arrest from the night before. You'll have an arrest where a person is pulled over for failing to make a right turn. That's its own criminal violation. They then took a little while to get pulled over. They drove through the neighborhood because they were hoping that the officer wasn't actually looking for them. Then we have a misdemeanor eluding. Then we finally get to the point where they've met with the deputy or the police officer or the state trooper. They've started talking. They give some false information about their driver's license. Then we potentially have our interference there. Ultimately, we boil down to the fact that there's a DUI and there's an open container in the vehicle and their passenger has a bag of weed. So we've got 6 potential charges. So we look at it and as prosecutors, we say, well, what is the most, let me add one more. Sorry, this is my favorite, is the no seatbelt and the no insurance. So now we're up to 8. So for myself personally, there's a few things that are really important to me in my office. We never dismiss a seatbelt ticket. We never do, because we want to encourage, you are always wearing your seatbelt in Sublette County. Also with insurance, we never dismiss an insurance citation because those are 2 that are there. But we look at it and we say, okay, our most important of that group of those 8 is the DUI. That's the one that has the most effect in the community. That has that because the DUI creates the most danger. So then in our negotiations, we start saying, we're going to dismiss this, we're going to dismiss that, we're going to do this, we're going to do this penalty on this one, so on and so forth. So we start in that conversation. So yes, we have these ability to negotiate and we have a lot of, we still have a lot there. On the other side of that spectrum, when we have one charge alone, where you are prosecuting, let's say, for example, not a DUI, but you have one potential charge, and that is a domestic battery. And you're being told through the legislation, this is a class, this is a grade 3 for discussion's sake. I know that there's no proposal of what this is going to be, but let's say for discussion's sake, the legislature says that domestic battery, our one count of domestic battery that we have to work with, is a grade 3. And let's say for discussion's sake, that has a minimum and it has a maximum. And we, the collective we, as the state of Wyoming, through you all as legislators, have said that we want to make sure that every person that's convicted of domestic battery spends at least 3 days in jail. So we have 3 days to 180 days. That mention of your minimum on that limits the ability to have that discretion and limits the ability for us to address the individual nature of that crime. And I'll give you an example on this. So for discussion's sake, in domestic relation situations, you can often have a traditional abuser in that relationship. And you've created and you've gotten into this realm of, in this relationship, that the dynamic of violence has just been built and lives in that dynamic of violence. And one day, let's say spouse, and this is generally, let's say that the perpetrator of violence is generally the husband, and the most likely victim is the wife. This is generally how it operates. Husband is generally doing it. And then one day, wife, because of this dynamic in the relationship, slaps husband across the face. He decides to call law enforcement and says, hey, I just got hit in the face. There's a red mark on my face. It hurt. Therefore, we've checked all the boxes for domestic battery. She is arrested and she's taken away. We want to be able to look at that situation in a totality of circumstances there. And if the legislature is telling us, and they've limited it and they've said you're a grade 3 because it's domestic battery, we are now in a realm where we look at this person who did check every box in the violation of the statute, and now we have a mandatory minimum on that. When I am hoping that you all saw that maybe that person isn't the person that needs to be addressed and dealt with. And if the legislature is telling us, you look at that committer of domestic violence the same as you look at the other committer of domestic violence, that's where I mean with that limitation of discretion. We want as much discretion as we possibly can have.
So it seems to me your concern is about mandatory minimums as opposed to a classification system perhaps based on maximums. Is that fair?
I think that is fair to say, yes. And I think that does reflect the understanding of the group.
Representative Chesty.
Thank you, Mr. Chairman. So I get back to the same issue. Well, how is, if we have the classification system, how is that a more of a mandatory minimum sentence than the existing regime? When the existing regime, the statutes say, here's a minimum, here's a maximum. Why is that not itself a mandatory minimum? How is the classification system worse than what we have? I don't get
Mr.
it.
Malinkovich.
Thank you, Mr. Chairman and Representative Chestik. As is borne out in that spreadsheet, the vast majority of criminal offenses in Wyoming are no mandatory minimum, and there's a range at the top. So we are a 0 up. That's the vast majority of criminal offenses. And so if we start getting into a classification system, that's where, in my mind, visually, I look at cubby holes. When we have like a cubby for these ones, this is a bucket, this is a bucket, this is a bucket. And this is a hard conversation to have without understanding what those would be. And again, please don't look at the County Prosecutors Association as being obstructionist to a legislative goal. We just want to participate in this process and are generally seeking rhetorically what is that goal. And that's where, when we get farther along this path, I think that we can provide a lot more feedback as that goes on.
Representative Kelly.
Thank you, Mr. Chairman. And please bear with me for a moment as I lay this out to make sure I understand what's going on here correctly. We have this spreadsheet, which is kind of a mess of maybe some antiquated laws, inconsistencies, and some confusing and conflicting ideals. So there's an issue. The legislative fix of possibly cleaning this up and categorizing, you're saying, would cause more issues than it solves, even though it may sound good from our perspective. It's another layer, more obstacles for you to jump through as you're trying to do your job. Would you say that's fair? That's fairly correct?
Mr. Chairman, Representative Kelly, I think from a 10,000-foot view, yes. By no means are you going to find a prosecutor in this state. If you give them an hour of time, they will tell you a variety of places in the criminal code, both in Title VI and a variety of places that could use some tune-ups from the perspective of us understanding the legislative intent with crimes. And so I think what we are saying is that before we get to uniformizing, if you will, a penalty scheme that includes gradients, let's look at and fix some of these other problems in criminal prosecution that are more important. For example, and this is borne out as a representative from our group, before we look at this, let's tune up Title 35 when it comes to controlled substances. There's a variety of significant issues in controlled substances that create problems for legislatures on the daily. So yes, to your point, and this is where I'm really hoping to pivot to Ms. Hackle as well, because she's much more entertaining and more eloquent than I in these matters.
Yeah, we need a scheduling order in terms of time. I think Clayton's burned up all of Ms. Hackle's
This is the
time.
problem is that
You're not getting paid by the minute.
it's true.
You don't have to talk so much.
As my old man would say, I run on a nickel and somebody put a quarter in me. But to your point, 10,000-foot view, yes, this could increase the complication for us to do our jobs.
Follow up?
Yes, sir. There is a follow-up. Thank you, Mr. Chairman. So well, I'm looking at this right now and I'm speaking as an educational professional who, for me, AI systems have become a bane of existence as I deal with people who abuse them constantly. So I'm by no means speaking as a fan of them. What would you think of utilizing some of the artificial intelligence tools we have now to analyze and classify data, to run this mess through and red flag for the legislature, whether LSO did it or your association did it, to point out some rough spots that we should address specifically rather than do a big overall gradient system? Does that make sense? And does that also make sense from the perspective of not piecemeal asking different prosecutors to tell us where they think spots are? Does that seem to make sense? For me, Mr. Chairman, that seems like possibly a way we can deal with this without making things harder on everybody.
Mr. Blinkovich, response?
Thank you, Chairman Washington, Representative Kelly. And I think the simplest answer on that, you're not going to get objection from our organization in trying to clean up some of those problem areas. And we are happy to participate and want to be engaged in that process. I will be candid, we probably don't have the bandwidth to go through and do that on our end, but we are happy to participate in that process and would be grateful for any opportunity to help simplify and clarify the criminal code.
So if we form a working group, we're getting some volunteers from your association.
I can say yes, because I would be a volunteer as well in that situation. And I can promise there would be many people as well, especially you heard from Ms. Hackle yesterday. She's here in Cheyenne. She's very knowledgeable. And I know that you would have at least 2 people participating in that working group.
Senator Cole?
Yeah, thank you, Mr. Chairman. And sorry, it took a little bit to come around to this question, but are there any laws that, in the state of Wyoming that you think are appropriate to have a mandatory minimum on for committing a certain crime? Are there any laws that would that fit? or they all have to be, just your opinion. Thank you, Mr. Chairman.
Mr. Milinkovich.
Chairman Washington and Senator Kolb. I hear Sylvia talking under her breath on that one, and she's saying the same thing I'm saying, which is yes. Yes, there certainly are.
Ms. Hackle, do you want to chime in?
Thank you, Mr. Chairman. I get to speak. And I'm not bringing nickels next time to this meeting for you. I think everything that's been said here, in response to Senator Kolb's question, we already have crimes that have mandatory minimums. And they're usually the very serious ones, aggravated assault, aggravated robbery, those kinds of crimes committed with a gun. So I would hate to see that go away. If I might, Mr. Chairman, going back to Representative Kelly's comments, finding the problems and fixing them might be more beneficial to the criminal code as a whole and less overwhelming than first going through and categorizing the crimes. There are problems in the criminal code. There are inconsistencies. And this has since been changed, but when I first started practicing law, which was in the past century, to which Mr. Milinkovich referred, you got in more trouble if you rustled cattle than if you killed somebody's dog. And that may still be the case, but you only had to meet a certain financial threshold to hit the felony level if you were taking livestock, but it was a much higher financial threshold if you were doing other things. And to me, I was a baby public defender back then. It didn't make sense why that would be the case. And also as a prosecutor, because I thought those people should be prosecuted as well. For me, if I might, Mr. Chairman, the question is, what is the harm you're trying to solve? If in fact it's to clean up the criminal code and the inconsistencies and the things that don't make sense, the crime of hopping on a freight train, that sort of thing, I absolutely agree that that needs to be done. And I believe that the association would support that. Speaking both for myself and based on the conversations I've heard, as a group, we don't tend to see the point in classifying everything. We've got some real broad classifications now that we all work with: low misdemeanors, high misdemeanors, or misdemeanors as a whole, and felonies. We know those differences. We know how to charge them. It dictates where the case goes. Does the case stay in circuit court? Does it go to district court? It's a system that it's not maybe as consistent as people would like based upon the definition of the crime, not based upon the classification. But so I would ask you to be very specific within your own legislative body. What's the problem you're trying to fix? My personal belief is when you answer that question, you'll see that cleaning up those places in the code might be more beneficial to solving that problem than merely a classification system. And Mr. Chairman, one last comment, because I didn't get a quarter's worth of time. I did work for the federal 10th Circuit for a while, and I did appeals, and we had a lot that involved the federal sentencing guidelines. And it was kind of a fascinating project, but it was also sort of like being in a Chinese restaurant. We got to pick, you had to pick your crime from this set of columns and the offense from this, and you had to make them fit. And the appeals all concerned, did you pick the right crime in the right column? Now that's oversimplifying it to a huge extent. But a lot of the fighting was about what column did you place this in, not what on earth happened. And so, I thought it was kind of mathematical and interesting, but I don't know how much it went towards doing justice, but they still use it in the federal system. So I echo what Mr. Milinkovich said, absolutely willing to help with a working group, look at these statutes. I've worked with them a very long time. Don't have all the answers, don't even have all the questions, but am more than willing to assist in any capacity I can.
Mr. Co-Chair.
Thank you. I think one way that I I'm kind of envisioning approaching this based on the conversation that we've had is maybe a series of working groups. I think the co-chairman and I kind of talked about this a little bit too. If you had a working group, for example, that was tasked with misdemeanors and would look at, because you have your 750, as you mentioned, 6 month, and then you have your 1 year, $1,000. So you get the high misdemeanor and the standard or low misdemeanor, wherever you want, however you want to look at it. But I think it would be important to look at all those misdemeanors and understand whether we've got them in the right category as the high versus the low. And then there could be a working group that looks at felonies as well, and compares and contrasts those. And from our perspective, it's just that every year the legislature adds criminal offenses. And when we do that, we don't spend any time hardly any time at least, looking at existing statutes to know whether we're just going with our gut, whether the penalty feels right or not. It feels like most of the time. And then a third category I would really be interested in a working group on is the mandatory minimums. Because I believe there may be some areas, you may be correct that there are some areas where it makes sense to have mandatory minimums, but we probably have some that don't even make sense anymore. I'm not a huge fan of mandatory minimums. I think they take away prosecutorial discretion. I think they take away judicial discretion. I think you lose a lot when you say this is the minimum versus a 0 to 20. So I would be interested in knowing which ones the Prosecutors Association believes we should keep and others that we should open that back up to have discretion, because it may have just been a legislature at the time that statute was created that for whatever reason thought there should be a 1 year, minimum, but maybe it just doesn't make any sense. So without spreading your group too thin, a couple of you in each of those working groups, I think would be tremendously helpful, and a couple of us in each of those working groups. And then we begin to compare and contrast. It sounds like we would be up against a mountain if we decided to do classifications, because you clearly don't want those. And we only proposed it as a potential solution to somehow comparing and contrasting these criminal offenses. So whatever way we can do that, Mr. Chairman, I think we're gonna begin to narrow down the path forward, but those are some of my initial thoughts.
Thank you, Mr. Co-Chairman.
Could I?
Representative Lane.
To respond.
I don't think there was a question in there. I think that was more of a comment.
Wouldn't you agree?
Mr. Milinkovich.
This is the problem, is you've got a couple of attorneys up here and we can't resist. I appreciate the idea of where you're headed with that. And if I might make a suggestion, instead of looking at it as where our current felonies, misdemeanors, and mandatory minimums, maybe divide up our criminal offenses in maybe 3 different groups, such as like property crimes, personal crimes, and other, and then you have that full gradient, including misdemeanors and felonies of a personal violence crime. And then that group is talking about assault and battery, and they know where that gradient is between aggravated and simple, and they talk through that process.
Thank you. Representative Lane.
Thank you, Mr. Chairman. Thank you for joining us today. Can you talk to me about, have either of you spent any time in other states practicing law? We heard about the federal a little bit, but have any of you practiced under a different mechanism for implementing punishments?
Mr. Milinkovich.
Chairman Washit and Representative Lean, I have not. I've only been licensed in the state of Wyoming.
And
Ms.
Mr.
Hatchell.
Chairman, Representative Lean, nor have I. I have been a member of the Wyoming Bar my entire career.
I forgot to mention, I did work in the federal system, which is a little bit different, as Sylvia mentioned, but I have worked in the federal system, but only in Wyoming.
Follow up.
Thank you, Mr. Chairman. Okay, given that, will you talk to me about plea bargains? I hear what you're saying, and if I had to sum this up, I'd hear you. What I'm hearing is we don't want to change this because it takes away our ability to create more plea bargains. Is that an accurate thought process?
Mr. Milinkovich.
Not necessarily more, but just to be able to be strategic and meet those needs. In a situation where you have a in the middle of a criminal prosecution, you are working directly with defense counsel. A lot of times it's the same defense counsel that you worked with before, especially in Wyoming. We're grateful to be able to work with folks that we get along with well. And you're ultimately trying to reach this goal of justice. What is justice in this certain circumstance? A lot of times you're working through what are victims' needs, what is a restitution claim, a lot of those situations. From my personal experience, I have prosecuted only as for the state of Wyoming at state level, but I have done defense work for both at the state level and then also at the federal level. And I'll give you an example. Ms. Hackle alluded to a sentencing guideline through the federal system. I had a client, he was in Sheridan, he was being prosecuted for the delivery of methamphetamine. There was a weapon that was found in the garage where he was operating a business, where he was ultimately arrested. And so in that process, as Ms. Hackle was talking about with those columns, in that circumstance, the federal prosecutor essentially said, here is the result, that this is the outcome, this is the only outcome, there's no opportunity to work around any negotiation. And that's what I mean. Because there was a weapon, and so you had your five-year add-on because it was a weapon. There was other situations that created a number of months that person was to serve based on that system, and it was very, very rigid. Not a whole lot of room to work and negotiate and reach that justice point, if that makes sense.
Follow.
I don't think we're looking at sentencing guidelines in Wyoming, but I understand the reference to how they fit together. Representative Ling.
Thank you, Mr. Chairman. My last one would be about maximum penalty usage. Can you talk to me about situations where we're not using them, situations where we are using them, and a little bit of the discretion that the prosecutors are using when we come to those?
Ms. Hackle. I'm going to change that. See.
Thank you, Mr. Chairman. Representative Lean. A good example would be second-degree murder. That is a statutory penalty of 20 years to life. And so often, whether we're talking about a jury conviction or a plea disposition between the parties where the defendant agrees to plead guilty, in this district, here in the First Judicial District, the judges do not like the attorneys to come in and say, we've agreed that you should sentence this guy to 40 to 45 years. It does happen, but it is not the preferred way. But we will go in and make a recommendation. And then the defense usually makes, sometimes it's the same recommendation, sometimes it's different. And then the court has the whole range from 20 years to life. Often we see 45 to 50 years. Child molestation and child pornography are another couple areas where you see some pretty hefty sentences, as you should. So we, at least in this district, we feel we cannot and should not attempt to limit the judge's discretion because the judge has the full range of sentencing. Often the defense and the prosecutor agree on a recommended sentence, and then I've been in the court when the judge has said, I think that's too light, or I agree, I'll go with that, or I'll make the bottom number this instead of what you asked for. So it's a real variety. And particularly with respect to judicial discretion, no matter how this work turns out, I recommend not touching it because it's very important to the administration of justice in this state.
Very good. I see we have the State Public Defender's Office on our list. Specific to the classification system. I know they all kind of tied together here, but we're kind of breaking this into the classification system, then we'll start talking about the others. But Public Defender, thank you both for being
Thank you.
here.
Thank you for having us and the opportunity.
Good morning. Really glad you could join us. Please introduce yourself for the record and tell us what you'd like us to know about your view on classification systems for criminal sentences.
Good morning, Mr. Chairman. Thank you for having me today. My name is Patricia Bennett, and I am the State Public Defender. With regard to classification systems, one of the biggest concerns with the Public Defender's Office and probably Defense Counsel statewide, whether they're private or public defenders, is what we would like to see is consistency throughout the state. What we have concerns about is, if someone's arrested in one county on a charge and someone in a different county under very similar circumstances, we would like to see those people be able to be sentenced or even plea negotiations be somewhat consistent. We make a joke is, where depends on which county line you've crossed in on I-80 as to what you can expect for similar circumstances. And so that's something that we are concerned about. Looking at it just from that perspective, I believe that some sort of classification system wouldn't be the worst way to do that, because what that does is it does take specific crimes with specific circumstances and it puts them in buckets that have a narrower sentencing range. And so everything is going to receive some level of plea negotiations. So I don't know that it necessarily limits plea negotiations. I think that happens. Mr. Milinkovich was absolutely right. 98, 99% of all of our criminal cases end in a plea agreement. So I can see from that perspective where a classification system would be helpful. It would also help as far as getting consistent sentencings from our courts. As Ms. Butler explained, our courts are all individuals. They're all they are all their own entities, and they are fairly different across the state. So from that perspective, definitely I understand where that wouldn't be the worst idea. However, I also agree to a certain extent with Mr. Milinkovich. I think a wholesale classification system might be more than we need to do at this point. I like the idea of a working group where we look at, and I think his division is probably better, where we look at crimes against the person, crimes against property, because within all of those, there are misdemeanor offenses, felony offenses, theft being one of them, battery all the way from simple assault all the way up to aggravated assault. So I think looking at them in that way is more efficient and probably more consistent across the board than trying to divide them into felony and misdemeanor. So I don't disagree with working groups to take a look at some of our criminal code. A good example when we're talking about the classification system is burglary, and I've used this example multiple times. If you have two 17, 18-year-old kids that are out, acting dumb like 17 and 18-year-old kids do, and they're walking down the street flipping up vehicles looking for one that's unlocked and they steal a handful of change, that's burglary. If you have someone that sees that the neighbors are out of town and they invade someone's home and steal things from their home, that's also burglary. But those are very different situations. So in that type of situation, I can see where a classification would be helpful. But I don't know that we necessarily need to do that across the board.
Thank you, Ms. Bennett. Questions, committee? Representative Ling.
Thank you, Mr. Chairman. Thank you for joining us today, Ms. Bennett. Would you talk to me a little bit about maximum penalty and the way that comes through your office and how you see them? Are we using them as a benefit in Wyoming, or are they being used as a deterrent for more crimes? That kind of thing.
Ms. Bennett.
Thank you, Mr. Chairman, Representative Lean. I think we use maximum penalties in probably everything we do. We negotiate, and sometimes we negotiate in a way that a charge is dismissed and refiled, either lower or higher, depending on the circumstances. The maximum penalties limit plea negotiations. They limit what that person can receive. For example, we were talking about second-degree murder is 20 years to life. manslaughter is 0 to 20. And so what those do and what that adds is it gives you the opportunity to look at the circumstances and the defendant as an individual. And it gives quite a bit of discretion, but not so much discretion that if there weren't those maxes, I look at those as kind of speed bumps in that you can only go that so far with a sentence on a specific crime. That's different than mandatory minimums. Having worked a little bit in the federal system, I don't care for mandatory minimums. I understand that on a very, very serious crimes, they're probably appropriate, second-degree murder being one, and murder and first-degree murder, obviously. But when you start looking at some of the lower level crimes, what a mandatory minimum does is it takes out the ability to look at that defendant as an individual. As I think it was described a minute ago, you have very specific columns. You go from this column to this column to this column. This is the crime, but you don't get to look at the person as an individual. And I think that can be harmful because there is a level of punishment and a level of deterrence and incapacitation in sentencing, but there's also a level of rehabilitation. And I'm sure that my colleagues from the Department of Corrections will talk about rehabilitation, and we have to look at that. Sometimes a mandatory prison sentence or even a mandatory jail sentence is not appropriate for an individual, given their circumstances. What are they dealing with? Is it a substance use issue? More concerning is, have they committed a crime as a result of a mental health issue? Our prisons are equipped fairly well. They have some good programs for substance abuse, that sort of thing. But our prisons are not a place for the mentally ill. And I think we have to be careful when we look at mandatory sentences and whether or not we are able to sentence the person as an individual. So I think we have to be very careful with that.
Follow-up? Thank you, Mr. Chairman. You spoke about inconsistencies. Different counties receive different penalties. And so I'm wondering, is that a portion of us not having a unified court system across Wyoming? Or is that based on one prosecutor does their job better than another defender? Where is the discrepancy there?
Ms. Bennett?
Thank you, Mr. Chairman. Representative Lean, I think all of those things are a factor. And then when you're dealing with attorneys, you're also dealing with personalities. Our prosecutors, by and large, they are all elected officials. They all have people that they have to answer to. Our judges stand for retention. I don't know that it being a unified system matters necessarily, but you are dealing with different individuals that have to answer to their different constituencies. And so we have to take that into consideration. They're just different depending on where you're at across the state.
Further questions? Ms. Bennett? So the working group, I know that we've seen a lot in the news about workload for public defenders, but might there be public defenders who would participate in a working group to evaluate the sentences contained in our criminal statutes?
Thank you, Mr. Chairman. Yes, we would absolutely want to be part of that. I think that when we have different perspectives from different entities, whether that's judges and prosecutors, defense attorneys, I think we will come out of that with the absolute best product if we have those different perspectives. So we would be more than happy to participate in those processes.
Okay, thank you very much for being here. Anyone else in the room wishing to testify reference to classification systems? Good morning. Please state your name for the record and tell us what you'd like us to know about classification systems.
Good morning. Thank you, Mr. Chairman. My name is Jenny Craig. I am the Deputy Attorney General with the Wyoming Attorney General's Office in the Criminal Division. And the committee requested that we be here today to discuss this topic. I don't have much to add to what has already been said. I think that the primary concern with this idea of a classification is that in order to create different classifications, I think there's some concern that we're going to have to start condensing some of the sentences that are available for the individual crimes to make them fit into those categories. And one of the great things about the way that our sentencing scheme is set up already is that it affords a lot of discretion to consider the individual nature of not only the individual who committed the crime, but also the attenuating circumstances around that crime. And I think that there's just concern that if we start condensing that those facts won't be able to be taken into consideration as greatly as they are now. Not all second-degree murders are created the same. Not all aggravated assault and batteries are created the same. So it's important for the prosecutors, the defense attorneys, and the judges to have that ability to work within those broad sentencing ranges. And I understand that we're not suggesting sentencing guidelines, but I think there's just that concern that it kind of starts looking like that a little bit. And I don't want to speak for everybody out there, but I'm not sure we would find a lot of people that would say that the federal sentencing guidelines are the gold star for seeking justice in the criminal justice system, because it doesn't allow you to take into account the individual nature of the defendants, the victims, the crimes, and everything that goes along with that. So that would be my caution. I think that the system that we have works well. I mean, no system is ever going to be perfect, but I think that the way that it is set up currently allows us to juggle all of the different things that we're looking at. And you can never take away the fact, if we want to be able to have that discretion to consider the facts about the defendant, I mean, we also have to just accept the fact that we're also dealing with individual prosecutors, individual judges who all view things a little bit differently, but that's just part of the process. And I think that it works pretty well. But other than that, I would stand for any questions that you have, but I agree with everything that my colleagues have said.
So when you look at the criminal codes, do you see room for improvement in terms of that spreadsheet that the LSO put together for us? I thought was enlightening. Is there work to be done on the criminal code?
Mr. Chairman, I think there's always work that can be done. And the fact that we are looking, I mean, the last time that the criminal code has been revamped was 1982. And so I think that there's always room to look to make sure that as we're adding new crimes, as society and what society is looking for, what society thinks is important to be punished in a particular way versus things that maybe we don't think need to be punished as harshly anymore, those can definitely be looked at. And I agree with what Representative Kelly had suggested and what my colleagues had talked about, that I think that we can look at this in a more surgical way and looking at the individual crimes and how they fit within what the legislature thinks is proper for the state of Wyoming, as opposed to doing a pretty significant revamp, especially with how we're looking at sentencing and classifying things. I think that we could address some of the concerns more easily if we look at things individually.
Okay. And my golden question, is the Attorney General's office willing to participate in working groups towards this end?
Mr. Chairman, I think that the input from the prosecuting attorneys and the public defender's office would be far more valuable than probably anything that I could add, but I would be happy to participate if that's what the committee would like.
Okay. Questions? Don't say. Thank you so much.
Thank you.
Anyone else in the room reference classification systems? Mr. Thompson.
Thank you, Mr. Chairman. Alan Thompson, Executive Director of Wyoming Association of Sheriffs and Chiefs of Police. And I would just like to request that maybe law enforcement be considered for any working group. I know that this is a policy decision and doesn't usually affect the law enforcement, but there are times where elements of the crime might be changed in order to fit into a sentencing scheme. And I think having a member of law enforcement in that discussion helps understand the intent of what might come out of it on the other end and help inform our members should these changes happen.
Thank you. Appreciate the offer. help. Any questions for Mr. Thompson? Very good. Thank you, Mike. Who had a question? Oh, Representative Lean has a question for Mr. Thompson. An LSO question. Oh, very good. You're off the hot seat.
Sorry, Mr. Thompson. I was curious to know if Wyoming is the only structured criminal code that we have. Are we the only state that does it this way, or are there other states that have the legislative body writes the penalty and puts it into statute, and then we just move forward?
Are we the only one without a classification system?
Mr. Chairman, Representative Lean, I don't believe so. Wyoming is not unique in not having a classification or gradation system.
Good morning. Please introduce yourself for the record. Tell us what you want us to know about classification systems.
Good morning, Mr. Chairman, members of the committee. My name is Lindsay Simino, and though I am usually the behavioral health lady at Capitol, today I'm just a mom from Laramie County. When I testified before you, as far as interim topics, I specifically was asking for classifications when it came to physical child abuse. And specifically because of the case that involved my son in 2017. This is a door I have consistently knocked on since 2017 with my work here at the Capitol. And I am very excited to just see any form of this discussion happening. That being said, seeing all of Title VI included, knowing how this conversation has gone the last 10 years with just the physical child abuse statutes, all of Title VI felt like a heavy lift as the mom. As far as what is our goal here, that's really what I wanted to answer today. And I think what the goal is, as far as what the Judiciary Committee experienced during session, and with this interim topic specifically, is how do we provide justice in a way that is not insulting to victims and not insulting to the loved ones of those victims. And that is what we heard yesterday when we talked about reckless driving. Specifically, House Bill 8 and 9, both moms testified at that time that when they talked to law enforcement about what happened with their children, they were told that because of statute, they had limitations in charging and sentencing. My child and his physical child abuse case, it was the same thing. Because of the statutes, there were limitations in charging and sentencing. And so however the committee wants to go about it, I think a working group is absolutely reasonable as long as the conversation is continued. Breaking it down individually, I think moms are very vigilant. If that needs to happen, moms will show up and make that happen. Victims and victims' families will show up to whatever working group and meeting to make sure that those changes are made. I am only asking that the conversation continues in some form, and I thank you for that.
Thank you for bringing that perspective. I think I hadn't thought about maybe somebody from the victim services office, maybe Mr. Chambers would be a great person to have on that working group, or somebody in the victim services arena. That'd be good to have on that group. Thank you, Ms. Semino. Any questions, Ms. Semino? Thank you for being here today. Anyone else regarding classification systems? Clerks, do you have a issue with classifications of felony crimes or misdemeanor crimes? Don't see any eagerness to jump up. Judge Chambers, any from the judicial branch? Is this going to have any implications on our e-filing or software? Head shaking back there? Maybe you don't. Okay. All right. So, yes. Oh, Mr. Hanson. All right. Mr. Hanson, we're specific to classification systems. Are you out there? You coming in, Mr. Hanson? All right, Mr. Hanson, we're discussing sentencing classification systems. I know this is distinct from your area of concern, which is the sex offender registry. So if you keep your comments specific to the sentencing structure and not the registry, I'm happy to hear your comments this morning.
Chairman Washut, I appreciate it. Specifically when you get into these as a citizen, and you're talking about these classification levels, it's pretty important because even as you guys have seen, when citizens have tried to bring issues that are within these codes to you, even your own representatives have a hard understanding of which crimes are comparative to which other crimes. And so personally, I believe this would help in helping not only your representatives and everything understand that, but the public as well. And that then leads specifically into what I would like to address about a specific penalty that is being forced. And I can bring that up later within this meeting if that's acceptable, or I can present that topic now.
I think the challenge for us, Mr. Hanson, is that the sex offender registry is not a penalty. It's not a punishment for a crime. It may feel like that to some people, but in the legal sense, being included in the sex offender registry is not seen as double jeopardy. It's not seen as a penalty for the crime. And so our discussion today, as we discuss criminal penalties, is outside of the sex offender registration classification system.
And if I may, Representative Wash, should just say that I understand that the registry itself is not, something that is a penalty. But as you all have heard, and as everyone that I brought this specific issue up with, everyone realizes that this specific statute, 6-2 316 III, is being punished because they're having to register twice as long as if they, as other offenders who chose younger victims or worse conduct. And not one of you can say that that's not punishment. If I were to take this to court today, a judge would agree that that is punishment. And so, yes, I understand that the registry itself is not punishment. But what you guys have done as a legislative body is impose a punishment, a penalty that these individuals are not able to fix any other way but through this committee. And your committee has pushed this off and pushed this off, and you have been incentivizing these offenders who committed worse offenses for 18 years now. And you've made these offenders who committed less serious offenses register twice as often for 18 years, and they can never ask for relief from duty to register. They also are imposed much stronger penalties within the communities. They can be made to wear ankle monitors. They can be made to live further away from schools and parks. There are so many penalties forced upon these just from being placed into the wrong tier. And it has been shown there are 4 or 5 worst offenses with younger victims and worse conduct that register 2 times a year for 25 years. Yet you're making this 3rd-degree low-level offense register 4 times a year for life. It's time to stop overpaying your reporting agents to monitor lower-level offenders. It's time for you guys as a committee to fix the unconstitutional treatment that the legislative body imposed on these people. As a man and a Christian, I believe when you make a mistake, you admit it and take accountability and you work towards fixing that mistake. It's time for this committee to finally own up to the mistake that the Wyoming legislature has made and the unconstitutional treatment being forced upon anyone convicted of 6-2 316 III, sexual abuse of a minor. I appreciate being allowed to speak today. I understand that legally you guys can say the registry is not a penalty, but every one of you can sit here and not one of you can say that it's not more of a punishment that these people have to register more often and can never ask for relief from duty Yet had they chosen younger victims, they would be monitored less and able to get off. Thank you.
Thank you, Mr. Hanson. Appreciate you keeping that brief. And, you know, if you're convinced that this is in fact unconstitutional, then I encourage you to use the legal system to file that challenge, contact your own local legislator. Perhaps individual legislator will bring a bill. It doesn't have to be a committee bill to attend to these matters. And so appreciate you being here this morning. All right. Do we have anybody else in the room or on Zoom? Representative Senator Cole.
Thank you. Just to make a general statement on my part, I will never apologize. I will never support the lack of protection for children and victims of sexual abuse. I don't think it's appropriate. I think saying the legislature is doing the wrong thing, I guess it's your opinion. My opinion is I'm doing the right thing. And I promise the public I'll continue to do it with pride. Thank you.
Okay. Anything further? Okay. So I'm going to take about a 10-minute break and we'll come back and talk about the crimes themselves and see if the committee has a preference on which way we might want to go on the classification system question. Yeah. So we'll stand at ease for 10 minutes. All right, we get back to work. Mr. Fuller, why don't you talk to us a little bit about your spreadsheet and what it is and what it is not? And also enlighten us a little bit about the last time the legislature looked at the criminal code.
Yeah. So Mr. Chairman, before I jump into the spreadsheet, if I may, just a couple of kind of prefatory comments, particularly in light of the discussion. And the first would be, Mr. Chairman, members of the committee, is I would start with the premise, and the Wyoming Supreme Court most clearly stated this in a case, Billis versus State, that the legislature has the exclusive power to prescribe what actions are crimes and then to fix the criminal punishments for those actions that have been declared as crimes. I bring that up for two reasons. First, the spreadsheet, each row on this spreadsheet represents a decision by the legislature to make a criminal offense and fix a criminal penalty, for that offense, whether it's in Title VI or any of the other titles of the Wyoming statutes. The second reason I bring that up, Mr. Chairman, is kind of going back to the classification discussion. And each state on Ms. Nord's fact sheet that has that represents a legislative determination about how to classify criminal offenses and fixed penalties. And within those states that have adopted the classification systems, each state has done it differently. Colorado, for example, has in their felony ranges fixed mandatory minimums within those ranges. There is a minimum and a maximum of those ranges. Colorado, though, has also split out drug crimes in a completely separate classification structure and system. Colorado also has offenses, and unfortunately I don't have any examples right at the tip of the tongue, but have examples of criminal offenses, of felonies that are not placed in a class and keep a penalty separate. Nebraska, for their classification system, they also have minimums and maximums. They also have a class for just one crime. So first-degree murder is in its very own class with its very own penalty. No other crimes in that class. South Dakota, I'll bring that up as another example because South Dakota's classification system does not have mandatory minimums. Each of their classes only fixes a maximum amount. So, Mr. Chairman, on to the spreadsheet. Before I just kind of jump in, I'll just share a few general principles that may be helpful for the committee to consider. The first would be Wyoming law, as most states do, define felonies and misdemeanors. Felonies are any offense that can be punishable by death or imprisonment for more than 1 year. Every other offense that does not fix punishment at least 1 year imprisonment or more than 1 year imprisonment is a misdemeanor offense. Statute also prescribes default penalties for certain situations. So for felonies, if a felony offense does not specify a different fine, Wyoming law says that the maximum fine for those offenses is $10,000. For misdemeanors, and this is fairly common, although not extensive, I would say, but if a crime just says this is a misdemeanor and does not specify any penalty, Wyoming law says that the penalty is up to 6 months and up to a fine of $750. Most crimes are in Title VI, but there are crimes scattered throughout numerous titles. Title I, 31, 35, 37, 9, 41 for water, 37 for public utilities. The drug offenses are in 35. It spans the gamut. Game and fish, 23. So there are crimes everywhere in Wyoming law. Just a few general principles. The criminal penalties typically, I would say in preparing the spreadsheet, include a maximum fine and a maximum term of imprisonment. Some offenses include both maximums and minimums, and on the spreadsheet, you can see that there are fewer crimes with minimums. There are a handful of crimes of offenses that include only minimum fine amounts and minimum terms of imprisonment without specifying maximums. One example of that would be the recently enacted money transmitter offenses. Those offenses specify minimum fines and minimum imprisonments without maximums. When imposing a criminal sentence under Wyoming law, courts cannot fix a definite term of imprisonment. Instead, a court, when imposing a criminal sentence, must establish a maximum and minimum term within the limits that are authorized for the statute violated. The maximum cannot exceed the statutory limit, and the minimum cannot be less than any minimum provided by law. And then the minimum cannot be greater than 90% of the maximum term imposed. So just one example, a court could not impose a sentence for murder at 49 to 50 years because the minimum is greater than 90% of the maximum. Wyoming law also allows for deferrals and suspensions of sentences in favor of probation. I did not really get into that in the memo. The other thing I would mention is that some laws are characterized as high misdemeanors and low misdemeanors. I would say this is most common in Title 23 for the game and fish offenses, where virtually all of those offenses specified, if they are misdemeanor offenses, are characterized as high misdemeanors, which sets one fixed penalty, and low misdemeanors, which impose another fixed penalty. So in some sense, particularly for Title 23, there is that gradation system already. The legislature has characterized those offenses as low misdemeanors, high misdemeanors. Title VII defines high misdemeanors as those offenses for which the penalty authorized by law exceeds the jurisdiction of municipal courts. In Title V for the municipal court statutes, they are limited to offenses that provide for a 6 months or $750 fine. Those that go up to a year are not in the jurisdiction of that court. For the spreadsheet, and Mr. Chairman, thanks entirely to Ms. Nord. The spreadsheet is now posted online in I think a relatively readable PDF. You have paper copies. There are paper copies out as well. You also have the spreadsheet itself that was part of the e-notebook that Ms. Nord sent out. So, and the benefit of that is you can go through and sort by penalty, by color, to see all of the offenses that are in that all of the offenses that are 5-year felonies or 10-year felonies and so forth. Same with the fines. Those columns are sortable as well. A couple of notes just on what I would say are the limitations of this spreadsheet. I would call it extensive. I'm not sure I would call it exhaustive, though. There are certainly offenses that I missed. For example, contempt. I didn't include, Title I talks about contempt of court. That's not included in here. I did not include as well each individual speeding infraction because those are pretty well, they are quite divided by the amount over the speed limit that you're speeding, whether you're speeding in a construction zone, whether you're speeding in a school zone. This committee also undertook that review about 8 years ago and went through and redid all of those, all of the fine amounts for those. So those are not included in the spreadsheet. That said, I'm sure there are probably offenses in statute that I missed. Just by limit of time and limit of just my ability to review. I have included the information on the years the offense and or the penalty was amended for Title VI. I have not been able to complete that for the remaining criminal offenses outside Title VI. As has been mentioned and as you requested, Mr. Chairman, a lot of these offenses will say 1982 or 1983. And that is the last time, as far as I can tell, that the legislature undertook an exhaustive review and basically reorganization of the criminal code. As best I can tell, that process took at least 2 years. I would say maybe even into a third year. I would presume that this started in at least 1981. The legislature sponsored and enacted legislation in both 1982 and 1983. To complete this reorganization of the criminal code. So just because a crime says 1983 doesn't mean that's when it was created. That's just, again, the limits of time and ability to research. These offenses, almost certainly existed before that reorganization. The information that's on that first column of the description, it's an extremely brief description of the offense. It's not intended to capture comprehensive information about each element that is required to be proven for that particular criminal offense, or any subsequent or attendant court decisions that may apply to that offense. For example, whether a particular criminal offense has been declared unconstitutional, or has other caveats that courts have found. I have also not included in the spreadsheet any action for which that calls for only a civil penalty. I also have not included status offenses, those offenses those actions that if an adult commits that would not be a criminal offense. Some offenses do not have a specific penalty. Some statutes have offenses that refer to a different statute. I've tried to capture that in the notes section on the far right of the column. The spreadsheet is color coded. Candidly, no real system or thought process for the colors I chose. I just tried to choose different colors for the different amounts, the different penalties. In the left column, this is the fourth column, you can see the minimum prison term for the offenses. And like I noted, most offenses in Wyoming law do not have a mandatory minimum. I did color code in the far right column if an offense was already characterized or classified as a high misdemeanor or a low misdemeanor. So that is captured as well. If a specific fine is required rather than a maximum or minimum, I also tried to include that in the note section as well. Mr. Chairman, at this point, happy to go line by line through this spreadsheet. With that, I'll stand for questions.
I like the line by line approach. We got to be done by 7:30 tonight, maybe.
Tomorrow night, again?
So for those of you watching on YouTube, we have a list here of 1,043 or something.
Yep, and yes, and Mr. Chairman, that is on the website now, 12-02 in the online meeting materials.
Okay. So if anyone has insomnia, you always jump in and read the criminal code and see where we're at. I just can't say thank you enough for the work that went into this document. While it remains quite a bit of work ahead of us, I think this document really streamlines options for the committee. And so, committee, before we start taking testimony and stuff, I just kind of like to get a sense of the committee's preferences. I think there are a number of options available to us. One, we can just stick with Title VI and not look at the other criminal statutes. We can just look at crimes with mandatory minimums. We can just look at violent crimes. We can just look at felonies and exclude the misdemeanors. There's a variety of approaches available to us, each of which will dictate time and effort. And I know that summers and even-numbered years for those in the House who are running for re-election get to be very busy times, but we can form working groups. We can have a working group on misdemeanors. We can have a working group on felonies. We could have a working group on personal crimes, a working group on property crimes. A lot of different options available to us. Rather than dictating that from the chair, I would like to have a little discussion among the committee if anyone has a preference on strategy for how we might eat this elephant.
Mr. Chairman.
Senator Craigo.
Mr. Chairman, just a question. I guess I think what would really help us make that decision is what are we intending to have our product this year? Or are we thinking about a multi-year project? How much do you want to bite off because of the elephant? Because I think that's going to determine what we do and how far we go. And if, for example, it might mean simply doing Title VI this year and just starting the project. Or maybe it's just doing felonies. Most of the felonies are going to be in 6 and 7. Maybe it's attacking the felonies. I don't know. And it was your idea, Mr. Chairman. So I think maybe, how far you want to go really is going to determine what the rest of us are willing to do.
Great question. When this was put forward for interim discussion, it was specific to Title VI. And then as we realized how many of our criminal codes are scattered in the other chapters, we started broadening the spreadsheet effort. My thought is if we take a small piece of it, perhaps this year, we might learn from the process and discover perhaps improved processes that we might use in the future for other facets of this. Senator Kolb?
Yeah, thank you, Mr. Chairman. Well, I think being the fact that we're in an election cycle, fact is that a lot of people might not show back up again. I think the best course, from my point of view, Mr. Chairman, is to try to get a product out, try to take a piece that we can work this interim and get it done. Because there's no assurances that, frankly, any of us might, I'm sure I'll be here, but the body might change quite a bit. So I think the opportunity is, and it's a good one, and it's an issue you found. I think we should try to do as much as we can that's achievable during this interim, Mr. Chairman, to have something to have accomplished. Thank you, Mr. Chairman.
Further, Representative Lee?
Thank you, Mr. Chairman. I might ask that we go all the way to Title VIII because there's only one in Title VIII, and then that would get us, Title VII's pretty short. Just my 2 cents. It gets you to page 5, about halfway down.
So is your recommendation we take up one statute, 8-7?
No. The recommendation is that we use the
Oh.
first 4.5 pages of the spreadsheet.
Oh, okay. That would be a possibility. We'll see what the body thinks. Representative Filer.
Thanks, Mr. Chairman. I think too, there, a while back, the legislature also used to have an archaic law committee. And I think as we go through this, maybe we find those laws that are very archaic and maybe try to remove some of those out of the criminal code. That way we could kind of maybe shorten up the green books a little bit, but something that's not, really something that has to do with our society today, if that makes sense, as we do this.
Mr. Fuller, when you put this together, did you notice any outliers, anything that just kind of stood out?
Mr. Chairman, with the caveat that it's entirely up to the committee to decide, what's an outlier, what's not an outlier. I mentioned the money transmitter offenses having only minimums, no maximums. The only other item maybe I would note would be in Title 13, and this would be, not sure about the page number, it's on the bottom of, I think, page 6. Many of the offenses in the banking statutes also have mandatory minimums, and that's one area that I noticed, because if you look at most of the other offenses in the other titles, typical to Title VI, similar to Title VI, there's not, there's a smattering of mandatory minimums. Most of the offenses in this title appear to have mandatory minimums.
Interesting. Representative Lane.
Thank you, Mr. Chairman. On that note, on the Title 13, do you know, are those replicas of federal law due to the banking industry?
Mr. Fuller.
Yep, Mr. Chairman, Representative Lean, I don't at this moment.
Further comments from the committee about process? It's a big elephant. my recommendation is that, things like the game and fish statutes and banking statutes and some of those things, they weren't things that I was contemplating when I proposed a review. I'll tell you, the one that stood out in my mind was the felony eluding and aggravated assault, where the elements are almost identical, but one's a 5-year felony and one's a 10-year felony. That's one that jumped out at me. And so that's what prompted me to suggest that maybe we take a look at this. At the time I made that motion, I knew it was going to be a project. I didn't quite anticipate this. I think this is an enormous project. And so I appreciate the committee's interest. I think if the committee is agreeable, let's shrink this elephant a bit just to Title VI. Just look at Title VI. Just look at our criminal code in Title VI, and then work through it by color code. Look at the bright red ones, those that have 50-year maximums and death, and then maybe look at the little slightly less red 20-year to life type statutes, and it's break them down and work through them by severity of maximum penalty would be my strategy idea. The other option would be just today to form up working groups and have those working groups make their own decision about how to eat the elephant. And my suggestion would be, if we go the working group approach, that we might have a couple of different working groups. One focused on personal crimes, maybe one looking at property crimes, and see what kind of headway we can make. And the working group can come back to us in August and say, here's some suggestions for maybe how we might want to streamline this or expand this, or whatever the working groups might come up. Representative Chesty.
I was going to make the same suggestion. I think that doing working groups based on the type of crime makes sense to me. I mean, there's still a lot of judgment into what fits into what category, but a lot of that's already done by the section of the criminal code. There's a whole section that deals with property crimes, and others that deal with personal crimes. So I think a lot of that work is already done. So we can take a look. And it makes sense because some conduct would fit a range. If this conduct could be either a misdemeanor or a felony, depending on how bad the conduct was or who the victim was or any kind of other factors. So I don't think we can separate it out, misdemeanor versus felony. It's got to be by category, by type of crime. Makes the only thing that makes sense to me. So I would support breaking it down in that way.
Commentary on this idea? Any discussion?
Yeah.
Senator Craigle.
Thank you, Mr. Chairman. So, I mean, I'm not opposed to that if someone is going to decide which crimes go where. I mean, so 6.2, everything in 6.2 is going to be crimes against the person, 6.3 is offenses against property. Then you get into 6.4, that's morals, decency, and family. I don't know where that goes. And so you're going to, and then 6.5's offenses against public administration. I mean, the green books set out a title for each chapter, but that doesn't necessarily determine whether it's crimes against the person or crimes against, offenses against property. I don't know who's making that determination and who are we going to task with going through all of that. If you want to just divide it by chapter, I think that's fine, and say this working group's going to do 6.2 and this group's going to do 6.3. But I think that would be easier than saying person or property. Just do it by chapter if we're going through Title VI.
And Mr. Chairman, if I may,
Mr. Fuller.
one possible option trying to group the crimes so there's not, say, 7 or 8 working groups, would be to have Chapter 2, the offenses against the person, Chapter 4, the offenses against morals, because that does include some offenses against persons. Chapter 6, the offenses against public peace, that includes things like fighting. And then maybe Chapter 8, the weapons, would group together. And then Chapter 3, offenses against property, Chapter 5, offenses against public administration, and Chapter 7, offenses against public policy could go together. Chapter 9 are miscellaneous offenses that probably would fit better with, I think, the property type offenses. I think most in that Chapter 9 are not involving, victims like the others might.
Mr. Fuller, I think that's an excellent suggestion. So working group number 1 would deal with chapters 6.2, 6.4, 6.6, and 6.8. Is that correct? And then working group 2 would deal with chapter 6.3, 6.5, 6.7, and 6.9.
Evens and odds.
That make sense?
Yep.
Even and odd, basically, yeah. Simple enough. So let's start with the committee. I'd like to have 3 legislators on each working group without duplicating legislators on both working groups. It'd be nice if we could get 3. Maybe we only get 2, but it'd be nice if we could get 3 on each working group. Representative Lean, which one would
Mr.
you
Chairman,
like?
I volunteer for the evens.
Evens.
I will as well.
And Brady for the evens.
I'll do the odds. The odds are the property.
Jessica will go with the odds.
I'm an odd one.
I'll volunteer for the odds, Mr. Chairman.
Singh goes with the odds. Need one more for each.
How about some senators?
They're kind of quiet over here, I've noticed. Any senators interested in a working group?
There's only 3 of us.
I think we should volunteer Senator Hicks.
Senator Hicks will be on both working groups. Is that the plan? Never miss the meeting, huh?
Senator Crum.
Senator Crum?
He was online earlier.
Is he off?
Well, we have 2 there. Senator Hicks, Senator Crum.
Mr. Chairman, you can put me wherever you need.
Okay. I'll put Senator Crago on the evens. Senator Olson.
I guess I'll take team on.
Senator Olson will take the odds. Okay, we have legislators. Then as we look back at some of our volunteers in the earlier hour, we're going to look for some prosecutors, at least 1, preferably 2 for each working group. And I'll leave that to you to communicate back to the committee the names and emails and phone numbers for 2 prosecutors for each of those working groups. And 2 public defenders and 2 lawyers from the private sector. Okay. And chiefs and sheriffs, at least 1 on each working group. I'll take 2 if you have them. Okay. And then somebody from victim services. So it could be Ms. Chambers, it could be others who she recommends from district attorneys often have their own victim services units. Some of the law enforcement agencies have victim services, but I'd like to have somebody from the victim services area. And then the judicial branch. It'd be great if we could get at least 1 judge for each of those working groups. And then so I'd ask within the next week, if you would communicate with Mr. Fuller at the LSO, the names and contact information of your appointees. If you haven't been able to finalize within a week, please let us know that it's still a work in progress. You haven't yet firmed up. I know sometimes it's hard to get people to step up and commit. Okay, that makes sense. And so the committee knows I'll do my best to participate in both working groups. Okay. since I brought the elephant into the room, I'll stand behind him, okay? And so Ms. Butler will be on both of those working groups. Clerks, anybody want to be on a working group? See any interest or need for clerks to be on this working group or not? Not necessarily in your bailiwick, but yeah. All right. So we have a structure, kind of a process to start taking the spreadsheet, carving it up into pieces, examining anything that just looks unbalanced, right? If there's outliers as you define them as a working group, if there are policy issues that you say, you know, we're not sure we need a mandatory minimum in 2026 for riding on a freight train, right? Come back to the committee with your recommendations. If you say, hey, good as written, no changes needed, that's fine too. Statute by statute within your sections. If you come up with process improvements as you work through these and say, you know, if we take up Title 35 next time, or we take up another title next time, maybe we should do it slightly differently. Boy, wide open for feedback from the working groups. Okay. And for members who did not volunteer for a working group, if you want to participate, I encourage you to do so. I think the working groups, maybe you can't make every one, but certain things, you know, as you look through the spreadsheet, you go, really? Feel free to communicate with those working groups. So I think what I'll do is appoint a chairman for each of those working groups who will kind of organize the meetings of each of those working groups. So Representative Lean will chair working group number 1. And Representative Chestick will chair working group number 2. And so it's just your responsibility to schedule the meetings and times, probably be done over Zoom, to proceed through these things. Now, Mr. Co-Chairman, as I understand, working groups are not compensated. Is that the classification there?
Yes, Mr. Chairman, the working groups are not compensated, but we can utilize staff for the working groups.
Okay. Chairman, do you understand that you can lean on your LSO staff?
So there might be some coordinating, trying to get them their availability for the meeting.
Right, through
first.
the summer.
Yeah.
But they can set up the Zoom meetings for you. They can communicate with all the members once we have those folks identified from the various stakeholder groups. Senator Kriegel.
Mr. Chairman, I was just gonna, couple things for staff, thinking ahead to our working group meetings. One, it'd be nice to get an updated, shrunk down spreadsheet for each of the groups based on the division that we've set up for the different chapters, so that those of us that are on the work group ahead of time could get the spreadsheet, be able to look through it. It's going to be much shorter and divided in half. And then I was hoping, that we could have staff available to help us, so that as we're going through, we could create essentially another column over here with recommended changes or none. Essentially, if staff could help us keep track of as we go through it as a working group, yep, we need to do this, we don't need to do anything, etc., so that when we get to the end, we actually have the notes we need to give to staff to do our bill draft, if any.
Mr. Fuller, does that sound doable? Okay. And I know staff has other committees, obligations and so forth throughout the summer. So the one advantage of having a large working group is lots of hands, lots of perspectives. The difficulty is Wyoming summers are only so long and people have busy lives and it's harder to get everybody together. But hopefully with a larger work group, even if everybody isn't available, if the majority is available, the working group can still plug through and get some good work done. Okay, that's my goal. Everybody clear on how we're going to jump into Title VI? And then, future meetings, we can discuss. We'll see how Title VI progresses before August. Maybe we want to take up one of the other sections of criminal statutes in addition to 6 if we progress quickly through the chapters in Title VI. At this point, I'll
Yeah,
take some public comment
Mr.
about.
Chairman, I was just gonna
Mr.
add,
Vice Chair.
yeah, progressing would be fun. I would really like to get to the crime for feeding a dog ground glass. I think that there's some important ones in shearing sheep's ears. So I'm hoping we can get to
Priorities
those.
have changed through the years.
Yes.
I was looking at desertion of spouse. Don't remember the last time I saw that in the newspaper, that somebody was prosecuting for desertion of spouse. But there's lots of things in here we can look at and take a look at. So now I'd like to take some public comment from folks in the room, as you understand how we're going to approach this. If you have thoughts or ideas, now might be the time to come forward and share whether you have a perspective on eating this elephant chapter by chapter in chapter 6, Title 6. Anybody in the room? Anybody on Zoom? Representative Bratton, you've been very quiet today. I'm going to call on you. Your perspective on this approach?
No, that's the spreadsheet was, Mr. Chairman, was quite a feat, and I thank LSO for putting that forward. And even though I didn't officially offer to be on either one of these 2 committees, I am definitely interested in following along and participating in them. So thank you.
Anyone else? Okay. I just want to thank the stakeholder groups that I know everybody's busy. You've all got plenty on your plates, and for members of the agencies and chiefs and sheriffs and victim service coordinators and others who private counsel are going to step in and contribute to this civic effort. Thank you. I think the end result will be worth the effort. I really do. It was eye-opening to read through the spreadsheet. If you haven't had a chance yet, I encourage you to pick up a coffee or go online and take a look. The variety of crimes and penalties that have evolved through the years. One thing that would be interesting is we get electronic talking, working on our electronic court records, is if we could figure out a way to see how often different statutes are actually prosecuted, enforced, and how many of them are there primarily as a deterrent, but nobody's ever getting prosecuted for feeding glass to a dog. Maybe we've deterred all the vicious people who would feed glass to a dog, and therefore, but as we talk about deterrent, we talked a little bit about deterrence yesterday. Seems to me that deterrence only works if people know that it's a crime, and number 2, what the penalty might be. And I've often thought, Mr. Thompson, that publicizing criminal penalties in our jails would be a wonderful idea. The word could spread. Did you know? Yeah. So with that committee, it's 11 o'clock. I don't want to move into the 1:30 afternoon topic in case there are other people out in the state that are going to want to participate in that discussion, thinking it's going to be this afternoon, and only to find out that we dealt with it, dispensed of it before lunch. So with that, we're going to break for lunch. We'll come back sharply at 1:30 and jump into our afternoon session. No objection? All right, we'll stand in recess until 1:30.